Good evening, everybody. This is Sam Shihab, and with me,
Brian Burke.
and we are from the law firm of Sam Shihab and Associates, and we're going to have a presentation today about the top 5 immigration issues in year 2022. And without further delay, Brian?
Yeah. So number one is visa recapture. So one of the big stories on the tail end of 2021 was Build Back Better Act and its massive visa recapture provision that provided for about 800,000 immigrant visas being recaptured that were lost in the last 30 years. Joe Manchin sort of put a torpedo in that with his thumbs down, his big famous thumbs down on it. However, there still seems to be some life in the bill. President Biden says, negotiations are ongoing and that no can be turned into a yes. So in 2022, we will see if there is any life left in the Build Back Better Act. Sam?
Immigration visa rollover. Last year, we've seen thousands and thousands of immigration visas coming from the family categories into employment categories, only for USCIS to waste 65,000 of them. This year, in year 2022 or next year, we will be seeing more of the same, more immigration rollovers. Would USCIS waste more cases? Brian.
Yes. New H1b regulations. So in the middle of 2020, USCIS lost and settled a court case where they lost about 10 years of their H1b policy. And now they're saying we have new regulations forthcoming that will basically change the way the H1b visa program works. They've said before that they have new regulations coming and on these issues, and we haven't seen them yet. So in 2022, we'll see whether USCIS can put up or shut up on new H1b regulations. Sam?
More H1b litigation. ITServe filed a lawsuit in 2021 challenging USCIS's SEMIO memo, which essentially requires that every time an employee moves from one location to another, a new H1b petition be filed and a new filing fee be paid. ITServe filed that lawsuit in 2021. We will see it in 2022 settled in favor of the employer, and we will see a friendlier H1b rules next year. Brian.
New premium processing. So in October of 2020, a law was passed requiring USCIS to make available premium processing for new categories, most notably H4 extensions and EADs. However, in order to actually implement that, there has to be new regulations. Those new regulations have been sent to the Office of Management and Budget, meaning in 2022, we will finally see an expansion of premium processing.
Don't go back. We will be discussing each one of them in full detail. Recapture. What happened?
Well, Sam, probably about maybe 3 weeks ago, we were pondering whether there was going to be a big moment like the classic John McCain one on the repeal of the Affordable Care Act, where he famously came to the floor of the Senate and gave his big thumbs down. And we got the equivalent of that kind of on the Build Back Better Act. Joe Manchin went on Fox News and said, no, I cannot support this bill. However, it's not. That was not. Fox News is not a vote on the floor of Congress. So the talk is there still some life in the visa recapture provisions and ultimately the wider Build Back Better Act? What do you think, Sam?
Well, Mr. Manchin is no Mr. McCain.
Yeah.
Let's put it that way.
Yeah.
Because if he had that guts, he would have taken it to the floor and gave it a thumbs down. But not and doing that.
Get chased out of the Senate with pitchforks and torches.
But because he has not done that, he left the door open. And in one of the shorts I published, 2 days after he did that, he attended a meeting he caucused with his fellow Democrats about how to move this bill forward. So I feel that there is life to it in one form or another.
Yeah, so I'm a man of two minds for this. In my shorts on the day of, I was thinking more like, well, how are we going to get visa recapture now? And I think of it, I think of anything, this Build Back Better Act, what we've been monitoring visa recapture provisions for a while now. And it seems like it's kind of a bipartisan issue, and even if the Build Back Better Act doesn't happen, it's something that requires 60 votes. And I think, even if the Build Back Better Act doesn't happen, I think there are 60 votes out there for a reasonable visa recapture provision, because I don't think anybody really likes what's going on.
So do you think it's going to fly on its own?
I'm hopeful. I'm more hopeful for the Build Back Better Act. See, on that subject, I mean, Joe Manchin was pretty clear in what he said on TV. It's no, I cannot vote for this bill. However, it is up to Joe Manchin. Really, he's the least common denominator, the most, the Democrat who is holding up the most. He kind of gets to define what this bill is. And if I were the people who want to get this passed, I'd be going up to Joe Manchin and say, please, Joe, tell us what we have to do to get your vote. And thereby, I mean, the vote hasn't happened yet. It's still on the table, and negotiations are still ongoing.
Yes.
Yes.
On the immigration visa rollover, we have right now 450,000 family cases that are stuck, and there are no interviews. 90% of the consulates, per the State Department, 90% of their functions are down and continue to be down. They had a hiring freeze that finally in January they are going to release that and hire more people. Yeah. We now have the Omicron variant, and we have a major COVID problem, especially in third countries. Many countries that cannot manage the spread of of COVID, and that will contribute to more shutting down. And therefore, we are going to have a rollover.
Yeah, I mean, that's exactly where I'm at. I look at two things. COVID-19 causes slowness, already massive backlogs, and the understaffed Department of State. I only see the backlog getting worse. Now, I got to mention, Charles Oppenheim in one of his last events said, there's been greater demand at the consulates abroad because basically people have been stuck overseas and they want to get back to the United States, so they're just doing it through the consulate. However, in order, the consulate has to actually move those cases, and those cases aren't moving. Rollover. It's gonna happen.
Well, we've spent a lot of time in 2021 talking about filing that second adjustment of status. Remember? Yeah. There were some other opinions out there that saying, well, you can't do it, it's improper. We've stressed time and time again that it is absolutely proper and you should do it. And then finally, Ayla came out with an explanation saying, yeah.
Yeah, this is me putting a feather in our caps, a party hat on us, and giving me a pat on the head on that one. Yeah.
In 2022, the second debate is going to be, can you file a consulate case along with your adjustment case? We are not going to give you the answer to that today because that is going to be a major issue of discussion. Can I file a consulate case while my adjustment is stuck so they can race and see which one goes there, get to the finish line first for 2022? But whatever it may be, the rollover of visas from the consulates coming into the employment is something that it will absolutely going to happen. And we are going to have tons of green cards for employment based.
If they can only issue them is the challenge.
And if they cannot issue them, then obviously the recapture push is going to get greater and greater and more frustration with the...
And that's when people start, or protesting the streets, kind of contacting their representatives, because ultimately, again, we've seen this issue bubble to the top. It is in the national discourse now.
No, there's no question about that.
And that's only good for the issue overall.
Yes, with immigration visa rollover, we are going to see large number of cases coming to USCIS, and right now we do not see USCIS preparing, because it's almost like a tsunami. It's coming. You look at it in the horizon, it's coming. But if you're not preparing for it when it comes, you cannot prepare for it then. Yeah. So unless they're hiring now and preparing themselves, we don't see them being able to handle it.
Yeah, I sort of agree with that. I just agree with that analysis.
Yep.
Yeah. So let's hit on the next one. And this is one, I think this is a very ripe topic. So backstory. We're going to talk about H1b regulations. Back in the middle of 2020, it's a IT serve versus, I can't remember the exact title of the court case, but it's IT serve versus USCIS essentially. And IT serve challenged a whole lot of aspects of the H1b program, a whole lot of USCIS H1b policy. And essentially, IT Serve Alliance, the IT industry group, won this lawsuit. And what was undone was essentially 10 years of USCIS policy memoranda on H1Bs.
And our firm was very much involved.
Yeah.
And as a matter of fact, we probably supplied 20 to 30% of the plaintiffs in those cases.
Yeah. And I mean, it's a great result for people on H1B status and H1B employers, because the bottom line is, after that IT Serve Alliance case, the decision that was settled in middle of 2020, H1B cases got easier. There was no, denials for lack of a purchase order, or basically their documentation requirements really sort of loosened up broadly. It's a good time to be filing H1B directly because of that. So now there's new H1B regulations on the table, and Sam, some of these things on these H1B regulations, well, they sound sort of familiar. Here's what's on the regulatory agenda. Now, I realize I printed this thing in black and white, so it's a little bit hard to read, but I have it on my PowerPoint presentation, so I'll have to just scroll through it there real quick.
But as you do it, I want to add one more thing here that's very important. A new report was released recently that showed that the H1B approval rate right now is 97%.
Awesome.
And compared to the lowest, it's the highest ever in 10 or 15 years. And we experienced the lowest ever in the same duration during the Trump administration in a short period of time. And it's directly related to these litigations.
Yeah, so here's what's on the agenda. So one, revising the regulations relating to the employer-employee relationship. And that's a controversial topic for sure. That was kind of at the heart of all those nasty RFEs we were seeing, through the Trump times. This is interesting. Provide flexibility for startup entrepreneurs. I'm not even sure what exactly they mean by that, but it sounds like, well, we'll see.
Well, let me tell you what it means.
Yeah.
For as long as I have filed H1B cases, for as long as I've practiced law, big companies got treated like queens and kings, and small companies got kicked around.
Yeah.
If you're a big company, just sign the darn form and send it. You're going to get approved. And if you're a small company, we want your tax returns. You want your bank accounts.
Put the screws to you and make you work for it.
This is just to basically recognize that you got to help the small guy.
Yeah. So here's what's also on the list, because I think this is interesting stuff. Implement new requirements and guidelines for site visits, including connection with petitions filed for H1B dependent employers whose basic business information cannot be validated through commercially available data. So more site visits to basically check up on employers.
And I love site visits. I think site visits are a wonderful thing to keep everybody balanced. But the question is, you got to have, number one, well-trained officers, because right now I've seen a lot of people who absolutely have no training. Also, they must understand that they must respect the employee and respect the employer. What we see right now in some of the site visitation is the total humiliation.
Mean and nastiness, yeah.
Total humiliation of the employer or the employee for absolutely no reason. It doesn't address any of that. So professionalism has to be raised in the process. And I'm 100% for it. I think it's an excellent tool to keep everybody honest.
And the list keeps on going. So they were going to provide, quote unquote, flexibility on the employment start date listed on the petition in limited circumstances. I'm not quite sure, again, what they mean by that, but here's some more. Address cap gap issues. So that's the F1 cap gap, people who are changing from F1 to H1B status. I imagine the new H1B lottery system may have caused some concerns for USCIS on that front. Here we are. Bolster the H1B registration process to reduce the possibility of misuse and fraud in the H1B registration system. And here's the last, I'm going to skip that one, Sam, because I don't think that one's that interesting, but here's the one I think is most interesting. Clarify the requirement that an amended or new petition be filed where there are material changes, including by streamlining notification requirements related to certain worksite changes, among other provisions.
So why do you think this is interesting?
I think it's interesting because it sounds a lot. It seems to really dovetail into the topic of the H1B litigation, the Simio litigation.
Okay, so you think that this is they're trying to regulate the Simio memo?
I think it's a distinct possibility. Clarify the requirement that an amended or new petition be filed where there are material changes. Well, that's always the standard. Including streamlining notification requirements relating to certain worksite changes, amongst other provisions. I mean, streamlining sounds maybe getting rid of the Simio policy. Streamlining.
Well,
notification.
Words mean nothing at this level.
Well, yes, these words are less official than the official words that are to come.
Yeah,
sure.
Exactly. So they're just giving all what this to me means that we're going to look into the amendment issue. But beyond of what direction is it going to be, in a nasty direction or a helpful direction, We will see.
I mean, I can't help but think that maybe they're trying to hedge their bets, because I mean, you're right. You said earlier, Sam, that you anticipated, a favorable result for, H1b workers and employers on that simul litigation.
Which takes me to the next point.
Yeah.
Obviously, is H1b litigation.
Yeah.
H1b litigation started by I mean, when did H1b litigation started? It started by USCIS taking the most extreme positions on H1b filing, and we were telling employers, litigate, file your lawsuit, protect yourself, and finally get to the point where it got so bad that their entire livelihood was in question, these employers. So they litigated. We came out with this, they basically wiped out 10 years of H1b rules and regulations, which all of it was illegal, practically.
Yeah.
And we knew that. We knew it's illegal.
No, believe me, we made this argument every time. Your policies are, you say what your policies are, but your policies aren't law. But they made them tolerable. They at least issued you fair decisions within their wacky policies that we were certain that were illegal, and people live with it. And so they push people too far.
Yes. Yeah. So we have now one left, one major one left. It's called the H1b litigation for the semio memo, which requires whenever you move from one location to the other to file a new H1b, which is stupid. The whole thing about this H1b semio memo policy is to suck more money out of people for no reason. There is no positive policy that comes out of it. So what we have here is we have a litigation that is going to be resolved, that is going to be further break down the illegal USCIS policies that they have had for decades, and that semio memo litigation is going to be resolved, in my opinion, in favor of them.
Well, one of the, I mean, I was just perusing bits of that lawsuit recently, and one of the tenets of it is basically USCIS, you're stepping into the authority of the Department of Labor. And when I read these proposed regulations, I think the same thing. I think, even if this issue is this issue is done, and these regulations, I expect there to be lawsuits on that front. It's sort of the same sort of challenges that we saw to the USCIS policy memorandums, and basically everybody's primed for litigation right now. So it's gonna come. I think there's a very good chance.
And we can talk about litigation forever. Probably, hopefully, an AAO that's more reasonable. Because we've had issues, obviously, with the Administrative Appeals Office ruling 9 times out of 10 in favor of USCIS, and being just basically a board that doesn't really look at this in a fair way. Now they have to understand that we're bypassing them into court. Hopefully, we will have more positive results. New premium processing cases, including EAD premium processing. This is big for 2022.
This is like we have a couple repeat questions, and one of them is there premium processing available for my H4 case, for my EAD case? And the answer is, for the longest time was no, and more recently it's been, well, it's coming, but we don't know when. And now we have, some progress made. The law was passed in October of 2020. It took them about a year, but I believe it was sometime this month we got news that the regulations were sent to the Office of Management and Budget. And as I recall reading, they have to look at it. They have 90 days in which to basically make a call as to whether it goes out or comes in. The next step is essentially we will see a notice of proposed rulemaking that will tell us, because we don't even know what the text of these regulations are. But those regulations will come. We go see their text. They'll give the public time to make their comments on them, look at them, and comment and say we want more or we want less. It's coming.
The I-765 EAD can be reviewed in 5 or 10 minutes. Now they're going to charge you $2,500 to do their job.
I was looking at the numbers. I'm gonna have to give you an asterisk on the numbers. I believe it was up to $1,750 for the EAD.
So they're not going to charge you $2,500?
No, they're going to charge you slightly less than $2,000.
$1,750 to do a 10-minute job.
Yes, it says not greater than $1,500.
Okay.
So I keep on lowering the number on you, Sam.
$1,500.
Not less than. No, it's definitely going to be $1,500.
Yeah. $1,500. Okay. Not less than $1,500.
Yeah, not
it
less.
can be more.
Shoot, you're right. I'm reading that backwards.
so I'm back.
Number undetermined, more money that you.
The current what's the current premium processing right now?
$2,500.
We'll stick to that. Not less than $1,500. So I'm right. 20 at least right today.
Yeah.
Until next week.
It's Schrodinger's number. Yes.
Yeah. So $2,500 to do 10 minutes of work. So what's that? That's $2,500
I'm in the wrong business, Sam.
times 6, Brian.
Yeah.
Okay, that's $15,000 an hour. Okay, to do their job, to get you an EAD card so you can work. We'll pay them the money. Let them do their job. Fine. Okay. Hopefully they can spend the money on something useful and helpful to help another immigrant somewhere else. We'll pay it. Yeah. But it's absurd, but it's coming, which is great news.
No, that's perhaps a healthy attitude. There are I don't even maybe let's I hope they put it towards something useful. One of the things that comes to mind though, Sam, is when this new wave of premium processing, Sam, do you think there's going to be a lot of people that upgrade their cases to premium processing once these cases become available?
Within the regulations, they have provision to suspend premium processing.
Yeah.
But I can tell you one thing, they ain't going to suspend the EAD because it takes 5 minutes to make $2,500. Yeah. At least the other case takes about an hour, half an hour. The ones where you can make, basically it's stealing, basically. They're not going to suspend the EAD. You're going to get your EAD in 15 days by paying $2,500. I don't see it.
Yeah.
I don't see it. They don't have to train anybody to do an EAD.
It's
a stack of them.
A 7-page form with 3 of those pages being substantive.
1.5 being substantive.
Yeah,
because the old EAD form was 2 pages, and it did the job perfectly.
And it's basically the same information since then.
Yes.
So it's not really. Sounds good.
And that's what we have for what to expect in 2022.
Yeah.
And now, current events. Moving on. We're going to a little bit of a truncated presentation today because it's the last Monday of the year, ladies and gentlemen.
Get your questions. We're going to answer questions, though, Sam.
We are going to answer. We're not leaving anybody without a question answered, 100%. But current events. So the consulates that cannot interview anybody, okay, now waived the interview requirements. Didn't waive it, but gave discretion. They
can always call you in if they have a reason, for sure.
To the consulate to waive interview for anybody who got a visa before from their country of residence or citizenship on an approved USCIS case.
I like this, Sam. Government that this is practical governance. It's you can't do the work, so you don't make people's lives absolutely miserable because.
But here's where I have a beef. Okay. So up to this point, this is great stuff. Now, first time H1b, first time visa applicants who received USCIS's approval, who have been scrutinized by USCIS, okay, cannot waive their interview requirement except for those who are part of the visa waiver program, which basically European countries and Japan.
Yeah.
Maybe Australia, if I remember correctly. Now, why not? Hold on. Let me ask the question.
I have a good response for you, Sam.
I got to ask
your question.
I got to ask my question. I got to ask my question. Why not let the policy give, I'm not asking for a waiver, give discretion to the consulate, and the consulate can say, we're not waiving it right now, but for the 10%, 100% clear cases, we're waiving it. So why take away from the consulate the ability to waive some of those and categorically say, we're not waiving a single one, and the consulate are 90% dysfunctional today? Give me your answer.
Important security concerns. We want to meet these people in person and vet them. That's really good. Really
That's okay.
Your answer.
Do it. But why don't you give them the discretion to waive?
Because again, they want to meet you in person. They want. I've never been. Believe it or not, Sam, I've never been a consular officer acting abroad on behalf of the United States government. But I can't help but think that part of their job is a bit of gut instinct. they want to get you in front of them to make sure that you are, worthy of their discretion.
Well, I can tell you that I went through the consulate interview as a foreign person before I became a permanent resident citizen, and my visa almost got rejected.
Yeah.
Oh yeah, I submitted my visa. I gave them the visa, and he immediately pushed it back. It took him 10 seconds for him to be unimpressed, and I did something that was very weird.
Yeah.
I pushed it back to him. I guess I did. And he was surprised, and he looked at me, and he took it, and then he approved it. But
yeah, Sam, if you hadn't been there to advocate for your case by pushing it back across the table, he might have just,
So you think interviewing is a good thing because it may allow you to present yourself?
Well, I'm going to play the devil's advocate. I can't, Sam, I like technology. Why can't they just do these things electronically? Have they heard, all sorts of security concerns, but some sort of video service, some sort of remote.
Thank you.
Yeah.
Thank you, Brian.
Yeah.
Allow for a Zoom interview.
And
just say, hey, I'm not convinced. But the problem with Zoom interview, there's so much fraud.
Well,
cameras have biometrics capabilities anymore.
It's the United States. So, I'm going to advocate for those waivers, Sam, for you. It's the United States government. If you don't think the United States government can, can catch a fraud before it gets in front of a consular officer. There's so many other ways to catch a fraud.
Well, yeah, yes. But that's the current events. All right, so that's the current events. We're on schedule, 6:26. We're not too late.
Yeah.
So is there any current events that I've forgotten?
No, that was really the big
one this week.
Like a lot of businesses, the U.S. government, kind of goes to sleep for a little bit at the end of the year. So we're not hearing.
But here's another piece, probably, of information that everybody's looking at. The Biden administration looking at removing the travel ban that they've implemented recently and that was recommended to them because now the variant is everywhere. So there's no point to restrict travel. So that is going to be removed soon. Obviously, also they're advocating vaccination as a requirement for flying, which is across the board.
Yeah, I consider that considering how long it took them to lift the last set of travel bans when the birds is already out of the cage. The COVID was everywhere, and it still took them a very long time to lift those bans. And
but the recommendation has been made to lift them, and it looks like they're heading in that direction.
Yeah, I think it's pure hubris to think that a government, the policy of another country your travel policy can prevent a disease from coming to the United States.
Unless you're a very small country, you can control it. Certain countries prevent people from leaving.
Sure.
Like Israel is preventing people from leaving their country. Because you know that you're coming back.
And with all sorts of fun diseases.
Yes, very interesting. All right, so without further delay, we'll be back to answer all your questions. All right, fine.
Oh yeah, so let's check out what sort of fun questions we have here. So here we are. So as per your experience, are you seeing a flurry of upgrades to EB2? Downgrades were a mad rush last year. Are upgrades the same this year, or is it more calculated?
No, there is not a mad rush, but there is a significant EB2. But remember that the movement in the EB2 is a drop in the bucket compared to the movement that we had in the EB3.
No, good metaphor. The tsunami versus bucket drops. Yeah.
So there is definitely EB2 filings. I'm getting emails today and every day about EB2, and we're filing them. But
I think calculated is the right word because back in October of 2020, people just said, I need to get my case out the door. And but now, right now, it's hey, my priority dates now current in EB2. I've already filed in EB3. What are my options? People are really making choices rather than just rushing their cases out the door.
Yeah, absolutely. All right, good one.
Yeah.
Next.
This is from Presti Munjal. So, does traveling to Mexico result in denial of pending I-131? Want to travel to Mexico to extend I-94 so I can work for 180 more days beyond EAD expiration.
The answer is it depends whether it's your first I-131 or is that an extension of your I-131.
Yeah.
Brian, you want to?
No, that's really
Yeah.
kind of it. Yeah.
So if it's your first I-131, yeah, it's going to get denied. If it's an extension, so you've had an I-131 before and you're filing an extension.
Well, so this is an interesting question, Sam. I want to take it apart a bit more. So they're trying to get that 180 more day EAD expiration. It sounds like they're trying to get an I-94 to get an H4 EAD.
I appreciate the expansion, but I have an explanation for you. But I think you should explain that coming back on EAD on advanced parole.
Yeah. So basically, if you're trying to get an H4 I-94 to take advantage of an H4 EAD automatic extension, you're traveling on advanced parole is not going to help that. When you travel,
re-entering on advanced parole.
Re-entering on advanced parole. When you re-enter on advanced parole, you're not coming back on non-immigrant status, H4 status, for example. You're coming back as a parolee, meaning you're not going to get the benefit of, you're not going to be in non-immigrant status anymore when you come back to the United States.
But let me explain the question, because I don't think Preeti is going to come back. She, number one, wants to make sure that her pending advanced parole will not be denied. She wants to know. She knows, I think, that she needs to re-enter.
Oh, okay.
That's okay. But that further explanation, your explanation is very helpful for people to understand this point.
Yeah.
That, that what's going to happen.
Maybe she's wanting to travel, but not wanting to get her advanced parole. She's traveling as a non-immigrant, but not wanting to get her advanced parole denied, which is, a good thing.
But you can refile your advanced parole.
Yeah.
That should not hinder you from traveling and taking advantage of the 180-day EAD by coming back on H4 and filing your EAD. Yeah. Good question. All right, so let's take the next one.
That question. I like it when we interpret them differently.
So, so let everybody know we try. Let's go ahead and put the next one on.
Okay.
We try not to rush those questions because there's sometimes two things happen when you rush a question. Number one, you give a half an answer. And by giving half an answer, you really haven't answered the question fully. Yeah. And then a lot of time people want to ask a question, but they don't ask it fully. So we try not to just run through all those. We try to kind of take it back and on a back and forth mode instead of jumping around and answering a question, because simple answer leads to.
Yeah, I mean, there are times when we can't get to everybody's question, but when you answer a good question well, it's helpful for everybody.
Yeah. So if this is not your question, listen to it because it may relate to you, and then you're gonna say, okay, now I understand it better.
So this is a great question from Sweet Seller. So if walk-ins are allowed, is it okay to go for biometrics appointment on a day which is earlier than the date of appointment? Any issues in going earlier? So the general answer to that is no. There's no problem going earlier. They're pretty happy to take people early. They're sometimes happy to take people late, but you don't want to be in that category. So my only take is, I'm always concerned that if you have an appointment scheduled with USCIS, you make sure you're there for that appointment. So generally speaking, they were happy to take walk-ins and even earlier, but I feel really good about going on the day you're supposed to be there and getting that nice receipt saying you did exactly what you were told to do. Because I try not to muck around too much with what the government says.
So first of all, these biometrics people are contractors, and they're paid by the piece. And therefore, they want you to process, which is great, right? Take it out of the government's hand, give it to a contractor, and all of a sudden they're efficient and they're commonsensical, right? Yeah. They're not silly and stupid about how they make decisions. That's number one. So walk-in is wonderful, but the problem obviously is if you go there, they're busy, they cannot take you, they will not take you. So with that in mind, and then obviously it's a short trip. What's a big deal? They say sorry, you come back, you do it on your day. Yeah, it's not a big deal. All right, wonderful. All right, so taking on the next one.
Here we are. So, hi, Sam and Brian. What are the options for filing I-45 without the certificate of non-availability birth certificate? Does USCIS reject the I-45 filing in case of absence of these two documents? A great question.
Without the birth certificate and the non-availability certificate, normally they do not reject it because you do not have birth documentation, but you're going to get an RFE.
Yeah, you're going to get an RFE very quickly, and instead of giving you, you get one very quickly. The trend lately, I've seen them. It's these pink RFEs, RFEs on pink paper. They say request for initial evidence, and it's like, hey, we reviewed your case and you're missing one of the basic, sort of building blocks of it.
Yeah. My experience, I mean, obviously, your experience with missing documents like this will vary based on the administration and their attitude. In general, birth documents, if you've done your effort to give him something, I don't care how weak it is a lot better than not giving them anything at all. And I have seen situations when we went back and forth on complicated birth issues multiple times until it was resolved. I mean, I had a lady one time where she was born in what is now Israel. It was before Palestine. Then it went to the Jordanian Authority movement, and then Israel took control, and she is Palestinian. And the document that she's presented was a Jordanian document, but the property is Israeli. And then they're like, what is this? This is not a document. This country is Israel. How can you give me a Jordanian birth certificate for a country? And we had to go through the history, and they went back and forth several times, and then they accepted it. And these are a lot more complicated cases that you would get normally from a country like India, where it's a simple non-availability or a simple documentation. So whatever you got, send. It's better than not sending it.
Yeah, I mean, if you're gun to your head, your options are file my case or not file my case. File my case and get it in before your priority date rolls back.
Absolutely. So Rahul Roy, how are EB-based green cards processed by Department of State?
Oh, I love this question.
If you love it, you got to answer.
I
was under the impression that they are only processed by USCIS.
So the answer is no. They're definitely not only processed by USCIS, and it is possible to get issued a U.S. green card, an employment-based green card, without ever having stepped foot in the United States before. You can arrive on day one in the United States as a permanent resident.
As a matter of fact, I've done a case not too long ago. Well, no, it's been a few years, but it's all relative. This gentleman, I got him on an EB-1 as an outstanding researcher and scientist. He's never been to the U.S.
I can think of one we did maybe about 5 years ago. A gentleman from Ukraine, a software developer who had a U.S. employer. They did a perm. They did an I-140, and because he's from Ukraine and his backlog's not that long, he basically, after a couple years of work, he appeared in the United States and a permanent resident. So how does it work? Does it work though? So I will give you the executive summary. So once your priority date is current, you are contacted by the Department of State. The Department of State basically says, hey, it looks like your priority date's up. They always go by dates for filing, for the record, at the Department of State, don't they, Sam? Because that's, they're the ones who put out those dates for filing. Department of State says, hey, it looks like your date's coming up. Please start immigrant visa processing. And there's this office in the United States called the National Visa Center. And that National Visa Center office sort of pre-processes these cases. You submit your documents to the National Visa Center. They basically make sure your documents are in order. The documentary requirements are a little bit different from what you send to USCIS. But so anyway, you send these documents to the National Visa Center, and once the National Visa Center is satisfied, the NVC, because the National Visa Center repeatedly is very hard to say quick, the NVC sends the case to the consulate. The consulate invites you in for an interview. And basically, if you please the consulate that your case is legitimate and you're entitled to permanent residence in the United States, instead of issuing you a temporary visa like an H1b, H4, L1, etc., they issue you an immigrant visa, and you enter the United States as an immigrant. When you come to the United States, you will get a package of some forms to complete, and you'll send off, and you get your green card in the mail.
Done. Couple issues I'd like to mention for people who are thinking about that, because that could be a big route.
You had mentioned this earlier, yeah.
We haven't talked about can you do both at the same time. The answer is yes, but don't tell anybody because we haven't talked about it.
No, you just jogged my memory. I remember when I first started being an immigration lawyer, I used to hear of that conceptually, and it kind of fell away.
As a matter of fact, that was a preferred way. It was faster than USCIS.
Yeah.
So people would do that. But here's two things you should do now, in my opinion, that you should, if you're thinking about that, and you should think about that. Number one, it could be faster in the next year or two because it was 10 or 15 years ago faster. But right now, to do it, you have to file an action on an approved petition. Application with USCIS, it takes 6 months, 6 months to 8 months for USCIS to pick up the phone and call State Department, tell them, hey, we have an approved case you need to handle, i.e., send them a cable, really. Let them know. It takes 6 months to 8 months to do that. And that's a major delay. So if you're thinking about it, you can just file this action on an approved petition now and let it ride. It doesn't cost you anything. Well, it costs a little bit of filing fee, but if you want to do it in the future, you'll be ready to go.
Yeah.
And the second thing you should remember, and we're getting deep into the detail of this, is when you file your I-140, you could elect to check the box that says
Yeah.
I'm processing at the consulate. You can still adjust your status normally, but the cable is part of the I-140 filing, and you don't pay an extra fee, and it's done right
It
away.
depends on the box you check on the I-140 form, and because the trend for the last several years has been adjustment of status in the United States. Most form I-140s are done for people in the United States to check adjustment of status.
So if you're filing, for example, an EB2 now adjustment, unless you're downgrading the I-140, the I-140 is out again, you cannot do it. But if you're filing an I-140 with an I-45, you could elect to mark this box and have them send the information to the consulate. It doesn't stop you from filing your adjustment, but it sets you up for a consular processing possibly.
Yeah, and I got to say that, processing time for a consular processing case, you're really kind of at the discretion and the mercy of the consulate to bring you in. And we discussed one of our big topics earlier.
But it doesn't stop your I-140, I-485 from here from USCIS.
Yeah, but it takes, the consulates are slow right now. But it's possible that they can be faster in the future.
Yes. Next case.
So I know this guy, Gopinath Linga. So hi, Sam and Brian. As suggested, I filed my EB3 I-140 downgrade in October 2020 and recently filed EB2 I-45 as current. I came to know that I got one RFE on my EB3 I-140 application, but somehow after replying to that RFE, it got approved.
All right. So is there a follow-up?
I think there must be. Scroll on down.
Oh.
It has to be a separate question. I don't see a.
I don't see him. Looks like. All right. So Gopi, give us the rest of your question so we can answer, because
we'll obviously stop again if we see it.
But maybe here.
No, this is
Preeti. Let's go.
From Preeti Munjal, who's asking about I-131. It's the first I-131.
Okay. So it will probably be.
It will be denied if you leave the country.
Yes.
Yeah. So, and there you are. So we're going to keep on looking for Gopi's follow-up, but here we are. Priority dates, May 2014, EB2 India. Would it be beneficial to downgrade to EB3 now? Check out our copy of the Visa Bulletin, Sam.
Yeah, let's do it.
EB2 2014. Well, the problem, the big thing here is
EB2 India 214
is how so they're both numbers, both are in 2012. So Sam and I had sort of given up getting out our crystal ball to predict the Visa Bulletin. And here's what here's what my take on it is. It does not hurt you to have another EB3 I-140 approval based upon the same I-140. The worst case scenario is your EB2 date always stays ahead, and you've spent the $700 in the government filing fee, and you never need that EB3 case. If your EB3 case becomes current faster, you can file a simpler I-45 application. And one of the big sources of anxiety for a lot of people was that when's my downgrade going to be approved? My adjustment can be approved if it weren't for my downgrade. If you have a downgrade that's approved already, you don't have to wait for your downgrade to be approved when you file your adjustment in that category.
Right. But I don't see 12 coming soon anyways.
Yeah, 2014 EB2 India. Yeah, it's used to have a far time off in either category.
Right. And just remember that probably next month we are going to have not filing date, but final action date.
Yeah.
They're close to each other right now. But I think as time passes, the final action date will be further back in time than the filing date. So too early to tell. Praveen, stay on our show and answer that question when the priority date gets closer. We'll give you maybe a little bit better answer.
Yeah. Well, yeah. It's a question from Sweet Seller. So it's, what do you suggest filing second adjustment status when the priority date is not current? Well, I have an easy answer for that one. That's a impossibility. They will not allow you to do it. So I would not suggest it. You'll sign some paperwork. You'll send it on a nice trip in the mail, but it'll come right back to you because they will reject your case for it not being current. So unless you want some well-worn paperwork, yeah,
I agree.
Yeah. So we got Preeti doing a little bit of follow-up. So given that,
can't see anything else.
Given that, I got two. There we are. Given that slow rate of processing of applications in the Nebraska and the Texas Service Center, shouldn't USCIS proactively transfer cases to NBC, especially for cases with I-140 already approved? At this current rate, NBC will be done soon. So should USCIS be moving their cases around so they can more efficiently process them? Most certainly.
Efficiently?
So,
USCIS? Can you put those two words in one sentence, please?
yeah. Well, in defense of USCIS, words I don't say very often, they do move their cases around. One of the trends we heard back in maybe middle of 2021 was that they were moving adjustment of status cases to local service centers, local field offices, so they could be processed by the offices there. And I asked about this. I traveled to a lot of USCIS interviews, and I was hearing them talking about this. I asked them, what they're working on, just to make conversation, and they say, we got sent a bunch of cases from another office, and we, processed them out, and everybody was happy. So, do they move cases around? Yes, they do. Does everybody want their case out of the Texas Service Center? Heck yes.
My God, everybody's so frustrated with those people.
A common question is there any way I can avoid having my case sent to the Texas Service Center?
Yeah, and some people, when you send an EB, like when you downgrade, file a dual adjustment, oftentimes they will send it to the same service center because the first case some people are thinking about even withdrawing the EB3 and filing an EB2, hoping to land somewhere else. That's extreme measure. Eventually, the Texas Service Center will resolve itself, guys. This is not something that we haven't seen before.
I understand the frustration, but it's a little bit of hubris to think you can beat the U.S. government and the system.
I know they're slow, but they're making it too much of a big deal, hoopla on it. Unfortunately, it's slow, but it will move.
Yeah.
All right. Gobinath, here's the rest of his question.
Yeah.
At the time of my AB3, I don't submit medical. Do you suggest updating my medical for AB3? My priority date is April 2012. So his adjustment status RFP was responded to, was approved, and he did not submit a medical. Do you suggest submitting a? Yeah, sure.
It doesn't hurt. If your I-140s, if your underlying I-140 is approved and your priority date is current, I don't recall your priority date, whether it's still EB3 current, but if your priority date is current and your I-140 is approved, it means the only thing that's standing in the way of them approving, April 2012. EB3.
January 12.
So close.
Mm-hmm.
So still EB3 can potentially keep on moving forward. So if your priority date is current and your I-140 is approved, it means the only thing standing in the way of approving your adjustment is the speed at which USCIS is addressing cases.
Yes.
So.
All right. So Praveen, thanks. My spouse's place of birth are different in passport, and because places
are about 300 kilometers apart.
Do I need to do anything? Well, obviously you have a discrepancy in the record, and you got to resolve that discrepancy. I'm not concerned about the end result of your case getting approved because of that discrepancy, but you just gonna have to explain it. So you need to sit down with your attorney and say, here's what really happened. And then the attorney is going to say, these are the documentation we need to resolve your case.
Yeah, I consider that resolvable, but if you don't, odds are you can probably proactively get ahead of it, have something prepared in the event of any sort of question or RFE on the subject.
Yes. Next question from Murali Krishna Reddy Padala. Applied adjustment status in November 2020. Did not receive biometrics
November
yet.
2020. No biometrics yet. Can I do anything? Wow.
That's crazy.
Yeah.
Do you have a receipt notice?
He said the application arrived in Texas. So that's the first thing that really concerns me.
Yes.
If it's nothing yet, I'd say, do you get a receipt notice at all? Because I'd worry that your case was rejected and they didn't send it back to you.
Yes.
Can you do anything? Yeah, there's some things you can do. One of my tricks I sometimes try is I put in that you can go to the USCIS website and put in service inquiries, and one of them is for notice not received. And one of the ones, for this one you can attempt to say, hey, I filed my case in November 2020. I got a receipt notice, hopefully, and I haven't gotten what I know to be the next notice, being a biometrics notice. And see what's that, because you have to be careful. If you don't attend a biometrics appointment, they can consider your case abandoned, and that means they can deny the case. That's bad.
Yes.
Yeah.
Thank you guys for listening to us for year 2021. This is the end of the year for you and us in this presentation. We're coming back next year. We're going to make the shows even better. We appreciate your support, and you guys have a safe and happy holiday.